Okay, so in our last class we have discussed that what is prospectus. So basically the prospectus is invitation for offer. Whenever the company go for public offer, either it is initial public offer or later on public offer, document it invites to the general public that come and make the offer for the purchase of securities, shares or debentures and derivative etc. that we have discussed. So that is known as the prospectus. What is the purpose of the prospectus, that also we have discussed. And who can issue, section 23 also we have discussed, who can go for the public offer. Only the public companies can go for public offer, private company through the private placement. So section 23. Now I think abridged prospectus also I have little bit discussed, but again we will discuss. So today we will start discussion on the different kinds of prospectus, or you can say the different types of the prospectus. See, under the company's law there are four types of prospectus. You have to understand the names of those. First is the abridged prospectus, second is the deemed prospectus, third one is the self prospectus, and fourth one is the red herring prospectus. Now what is abridged prospectus we have already discussed, but I again telling you something, that for abridged prospectus we have to study section 2(1), okay, along with section 33. Abridged, as the name suggests, abridged means the short version of the prospectus. And when you read section 2(1), 2 clause 1, the definition section, that abridged prospectus contain the memorandum of the salient feature of the prospectus. That means it is not the full prospectus, only the some salient feature. Then the question arises in our mind that why this the abridged prospectus. See, the purpose for the abridged prospectus is to reduce the expenses of the public offer, okay. But at the same time there is the caution that the law has reduced the expenses of the company, but what about the common people who, as a general rule or as the very basis behind the prospectus, we read that the people who want to purchase the securities, shares or debenture, want to invest, must know about the true state of the company's affairs. So what about their rights in case of abridged prospectus? And so there is the section 33. Section 33 subsection 2, that talk about that before, if the person seek that I need the full prospectus, then that can be provided by the company. The full prospectus should be put at the head office, and if any person who is in default of that, in that case there is the penalty, and the penalty is that up to the 50,000 rupees the penalty is there, okay. So these are the provisions that are making the balance between the the both at the company at one side and the general public at the another side. Now the second one is the deemed prospectus. See, the name itself suggests, whenever there is this word deem, the deeming provision, that means it is legal fiction. It is actually not. So whenever in any provision you will find that then law shall deemed, that means actually it is not, but law through the legal fiction consider it as the same thing. So here deemed prospectus is basically that any type of the sale of, or the sale of the securities, the document through which the sale is formed, In that document there is no information, but because this document is actually to circumcise by the business communities to avoid the liability of the prospectus. So the law has considered that this transaction would be deemed to be prospectus. Section 270, where the prospectus has been defined, if you remember that section 270 has three parts, and therein first part is, suppose a company issue any document and that document is with the name prospectus, that means the company itself is saying that it is prospectus, it is prospectus, no further inquiry is needed. Second is that the self prospectus under section 31, red herring prospectus would also be prospectus, so this special type. And the third one is any notice, any advertisement, circular, or by any other form if company issue a document, and the basic purpose of that document is inviting the offer. As we in the contract law said, it's not the offer. Whenever there is the sale of the the securities, so one will have make the offer, then other has to accept it. So outsider will make the offer, company will accept it, but it is not the offer, it's inviting the general public that come and make the offer. So invitation to offer. Here in deemed prospectus, even it is not that inviting the people but actual sale, then also it is considered as the prospectus, just to the curb the instances, or to even catch those instances where these persons like the director, or you can say business communities, just avoiding their liabilities. So section 25 talk about deemed prospectus, and for that we have to discuss section 25. Just sharing the screen with you so that you can also read along with me that what is this deemed prospectus. Yes, can any of you read it? Section 25.
May I?
Yes, yes.
Section 25, document containing offer of securities for sale to be deemed prospectus. Subsection 1, where a company allots or agrees to allot any securities of the company with a view to all or any of those securities being offered for sale to the public, any document by which the offer for sale to the public is made shall, for all purposes, be deemed to be a prospectus issued by the company
Yeah, stop.
and all.
Stop. Abhishek, stop for a while.
Ji, sir.
Where a company allots or agrees to allot any securities of the company. So the very purpose is that the company either allots, that means the sale, or agreement to the sale, with a view to all or any of those securities being offered for the sale to public. Then the document by which the offer of the sale for the sale to be the for sale to the public is made, that document itself would be considered as the prospectus, deemed prospectus. And in that case, the requirement of the prospectus would apply for all the purposes. So from this first portion of section 25 subsection 1, we have learned that when the company agree or allots any securities of the company with a view to all or any of those securities being offered for sale, then the document by which this sale to the public is made, that document itself would be prospectus. Now, here, as if we see, actually that document is not the prospectus, is does not having any information, it does not inviting. Even if you see section 270, it's not inviting the offer, it in itself is the offer, or you can say even after the offer, it is the document through which you can say the sale of the securities is made. And so here actually the this document would not be prospectus, but law through the legal fiction created it is a prospectus, just to curb the instances that the business communities should not fall or should not do this thing otherwise also. Now read the later part.
Yes, sir. And all enactments and laws as to the contents of prospectus as to liability in respect of misstatement and in omissions from prospectus or otherwise relating to prospectus shall apply with the modifications specified in subsection 3 and 4 and shall have effect accordingly, as if the securities had been offered to the public for subscription, as and as if persons accepting the offer in respect of any securities were subscribers for those securities, but without prejudice to the liability, if any, of the persons by whom the offer is made in respect of misstatements contained in the documents or otherwise in respect thereof.
Yeah, stop here,
Subsection
stop here. So here, what would be the consequence? That this type of the deemed prospectus should also have to, comply with the rules or the regulation. That means even through direct offer of the sale of the securities would not result that the company would not have to make the information. So when we will discuss that what are the matters that has to be written in the prospectus, section 26 subsection 1 and 2, those rules has to be complied with, those rules cannot be avoided. And then if there is any misstatement etc, for those misstatement the consequences would be follow same as like in the with the original prospectus. Okay, now read subsection 2.
Subsection 2. For the purposes of this Act, it shall, unless the contrary is proved, be evidence that an allotment of or an agreement to allot securities was made with a view to the securities being offered for sale to the public if it is shown subsection A that an offer of the securities or of any of them for sale to the public was made within 6 months after the allotment or agreement to allot, or subsection B that at the date when the offer was made, the whole consideration to be received by the company in respect of
Yeah,
the securities had
stop,
not been received by
Abhishek.
it.
We need not to discuss further here. Basically, section 26 subsection 25 subsection 2 is about that how to prove that a particular agreement to allot the securities was made with a view of the security being offered. There is a question that this document was with the purpose of being offered the securities for the sale. So this section 25 subsection 2 will be talking about that rule of the evidence. Now you come to the section 25 subsection 4, that would have much importance for us. Yeah, 20.
Section 25, subsection 4, where a person making an offer to which this section relates is a company or a firm, it shall be sufficient if the document referred to in subsection 1 is signed on behalf of the company or firm by two directors of the company or by not less than one half of the partners in the firm, as the case may be.
Yeah. So it's saying if the person making the offer with this section relate is a company, it shall be sufficient if the document is signed by on behalf of the company or the firm by the two director or by not less than one half of the partners in the firm. So this rule also with respect to the finding out that what was the actual nature of that document, whether the document that is in the question, whether that document would fall under section 25 subsection 1, that means it was with a view for selling the securities to the public or not. So in that respect, if the offer is to the company or to the firm, in that if the firm, if the companies at two director has signed it, or in case of the firm, not less than half means half or more than half have signed it, then it would be considered that or it would be sufficient that offer was made. Now uh, come to the next is self prospectus, or the third kind of prospectus is the self prospectus. See, the idea of the self prospectus is, suppose the company want to make the public offer, but it does not want to sell all the securities at once. Okay, so suppose company want to sell 100 shares in the month of January, then next 100 shares in the month of June, then next 100 shares in the month of the October. So would be advisable to issue again and again the same prospectus, or is it proper to having the same prospectus to the effect, because it is within 1 year, and in within 1 year in the company the financial reality will not change, financial reality will remain same. So with that respect, to making the company it possible that the if the company is making the prospectus within 1 year, then they can issue the self prospectus, but whatever changes has been done, only those changes has to be published. So with this idea, self prospectus is defined, and some limitation etc with respect to the self prospectus. Section 31, please read section 31, self prospectus.
Yes, sir. Section 31, Shelf Prospectus. Subsection 1. Any class or classes of companies, as the Securities and Exchange Board may provide by regulations in this behalf, may file a shelf prospectus with the registrar at the stage of
Yeah,
the first
stop
offer on.
Abhishek for a while.
Yes, sir.
First line indicates that it is not that all companies are allowed. Only those companies, those class or classes of the companies, as the SEBI through its regulation in this behalf allowed, only those companies can go for the self prospectus. Okay? Yeah, read it.
Yes, sir. Yes, sir. May file a shelf prospectus with the registrar at the stage of first offer of securities included therein, which shall indicate a period not exceeding 1 year as the period of validity of such prospectus, which shall commence from the date of opening of the first offer of securities under that prospectus, and in respect of a second or subsequent offer of such securities issued during the period of validity of that prospectus, no further prospectus is required.
Yeah, stop here. So suppose the first thing, that who are the companies or the classes of the companies who can issue self prospectus. It's not that all company go for self prospectus. We have to see with respect to that the SEBI regulation also. In through the SEBI regulation, some class or classes of the companies are actually determined, and those may file a self prospectus. May file, that means allowing them there also, it's not compulsory, they may file. But when they want to issue or want to go for the the second or the subsequent offer of the securities, and this second or subsequent offer of the security is within 1 year, then with the registrar at the first time of the offering, if they have the idea that the second time or the subsequent third fourth etc, subsequent means at any time, they will making the this type of the offer between the 1 year. In that case it is not required that further prospectus is would be issued. Okay, now read section 31 subsection 2.
Section 31, subsection 2. A company filing a shelf prospectus shall be required to file an information memorandum containing all material facts relating to the new charges created, changes in the financial position of the company as have occurred between the first offer of securities or the previous offer of securities and the succeeding offer of securities, and such other changes as may be prescribed with the registrar within the prescribed time prior to the issue of a subsequent offer of securities under the shelf prospectus, provided that where a company or any other person have received applications for the allotment of securities along with the advance payments of subscription before the making of any such change, the company or other person shall intimate the changes to such applicants, and if they express a desire to withdraw their application, the company or other person shall refund all the monies received as subscription within 15 days thereof.
Yeah. So second is the second subsection is basically that generally we considered that within 1 year there would not be any much financial changes. But suppose there is any financial changes, the charge under charge section 100 of the Transfer of Property Act. Suppose charge is created, there is the change in the financial position of the company, that that this financial change is after the first offering, that means in the original prospectus these changes were not mentioned, and so these new changes, new charge, anything new that happened after the previous the offer, these changes has to be filed in the information memorandum. Now this information memorandum for the first first time offer, the original prospectus, suppose in the second time with original prospectus and this new information memorandum, these collectively will known as the self prospectus. But suppose there is the advance, the proviso is saying, suppose there is the advance payment with respect to the second offer and before the information memorandum is filed. In that case, the proviso is applicable and it's saying that the uh, shall intimate the changes, and if those persons express or desire to withdraw the application, then the company shall refund their money. So if they does not want to the change, or they does not desire to withdraw their application, they said that okay, even after this changes also we will not changing our mind, so they can go for, otherwise the company will refund their money within the 15 days period. Okay, so now read subsection 31 section 31 subsection 3.
Section 31, subsection 3, where an information memorandum is filed every time an offer of securities is made under subsection 2, such memorandum together with the shelf prospectus shall be deemed to be a prospectus.
Yeah. So the main prospectus and every time second time offer, third time offer, fourth time offer, the subsequent offer, the additional information memorandum, any changes, financial change or charge has been created, that information memorandum, as I said, both these document would be known as the self prospectus. So, okay, and shall be deemed, this self prospectus shall be deemed to be the prospectus. Now this self prospectus together with this self prospectus is deemed to be prospectus. Again it's saying the prospectus, that means the whole requirement of the prospectus has to be complied with. Now Explanation, you can yes, quickly read explanation also.
Ji, sir. Explanation. For the purposes of this section, the expression shelf prospectus means a prospectus in respect of which the securities or class of securities included therein are issued for subscription in one or more issues
Yes.
prospectus.
Issues over a certain period without the issue of the further prospectus. So it's uh, precisely defining that for purpose of this section, the expression self prospectus means a prospectus in respect of which securities or class of securities including therein are issued for subscription in one and more issues over a certain period of time without the further prospectus. But we have already inferred whatever given here from the section 31. See, whatever written in the section is the law. Even the marginal note of the section, like this section 31, and this section 31 is saying that uh, yeah, self prospectus. So even this section 31 is saying self prospectus. This marginal note is also not the law. Law is from subsection 1 to the subsection 3. Explanation also not the law. Explanation only explain. Explanation cannot extend the scope of the provision. So when we read section 378 of the Indian Penal Code, explanations are there. And when you read clearly, you will find that explanation are not increasing the scope of the provision. Okay. Illustration also not the law, they are just the clarification. There are some examples are there, they are also not extending the law. So law is actually within the sections. This is one of the rule of interpretation. So whatever written here in the explanation, we have withdrawn from the section 31 subsection 1 first part. Now there is a fourth type of the prospectus, and the fourth type of the prospectus is red herring prospectus. Red herring prospectus is basically the prospectus issued before the main prospectus. And why it is issued before the main prospectus, and then this red herring prospectus, like here self prospectus has to register before the registrar. So what is a red herring prospectus? Section 32 of the Companies Act talk about red herring prospectus. Come to the section 32 and read it. Yes, Abhishek, read it.
Ji, sir. Section 32, Red Herring Prospectus. Section 32, Subsection 1. A company proposing to make an offer of securities may issue a red herring prospectus prior to the issue of a prospectus.
Stop here. So here from the section 31, 32, subsection 1, it's saying that any prospectus uh, that is issued before the main prospectus is the red herring prospectus. And the purpose is the same, that the company proposed to make an offer for the securities. Now we will read explanation here also along with section 32 subsection 1 that clarify, only clarify. Okay, yes, read explanation.
For the purposes of this section, the expression red herring prospectus means a prospectus which does not include complete particulars of the quantum or price of the securities included therein.
Yes. So earlier also I have said that here, because it is written red herring prospectus, then issue of prospectus. The issue of prospectus को मैंने मेन prospectus पढ़ा, रेड हेयरिंग मैंने कहा प्रायर वाला prospectus, और इसीलिए explanation पढ़ना important था. So basically before issuing the main prospectus, when the company make an offer through any the document, that document does not have the complete particular, that the quantum, that how many shares will be there or what would be the price of the securities. Only just the trailer is there, like we see in the movie, no? So that type of the things is issued before the main prospectus is known as red herring prospectus. Now read subsection 2.
Subsection 2. A company proposing to issue a red herring prospectus under subsection 1 shall file it with the registrar at least 3 days prior to the opening of the subscription list and the offer.
Yeah. So before 3 days, uh, uh, you know, before issuing the red herring prospectus, it has to be filed before the registrar to the opening of the subscription list and the offer. And the registrar, when we talk about the misstatement, so the preventive and the punitive action both we will discuss. The requirement of registering the prospectus before the registrar is that the registrar will check that whether all the requirement has been complied with or not. The requirement of section 26 subsection 1, requirement of section 26 subsection 2, and when we read section 26 subsection 1, they are referring that SEBI that made the rules, because SEBI is the body enacted under the Securities and Exchange Board of India 1992 Act, and the main purpose of the SEBI is to protect the interest of the shareholder to interest of the third persons, and so the rules also has to be seen. Only by seeing section 26 you cannot completely find out that what exactly the matters that we have to write in it. See, in the company's law, at many times we have to comply with those bylaws. Otherwise, the whole document one cannot prepare. So the section 32 subsection 2 is saying that before issuing a red herring prospectus, a company proposing to issue the red herring prospectus shall file it. Shall file it. That means to which it is filing, the red herring prospectus has to be filed before the 3 days. Before the 3 days. So this is the requirement. It's not that before one day also the person is filing the red herring prospectus, and it was at the office of the registrar. Okay. Now read section 32 subsection 3.
Section 32, subsection 3. A red herring prospectus shall carry the same obligations as are applicable to a prospectus, and any variation between the red herring prospectus and a prospectus shall be highlighted as variations in the prospectus.
Yeah. Now see, understand it. That this is the main prospectus, and this prospectus will have all the materials as it is specified under section 26 subsection 1. And if there is any misstatement, if there is any misleading statement, then there are the consequences, uh, civil consequences also as well as criminal consequences also. Before that, it was allowed by the section 32 that uh, red herring prospectus has to be issued. And this red herring prospectus, suppose the company needs the prior information in the market, so that inviting the public, so that they can make the offer. But that time they don't have the idea that how many shares they will make for the offer or make available for the purchase. Maybe they are thinking about it, or at what price they will sell it. That is also before the deliberation, so under the deliberation. So that time they can issue the red herring prospectus. Now suppose in the red herring prospectus, what would be the consequence? The consequences are the same as the main prospectus. If there is any misstatement even in this red herring prospectus, or any misleading statement, same civil and the criminal consequences. And this prospectus and the main prospectus has only difference, that here the price of the securities has not been mentioned. The quantum, how many shares are available for the sale, has not been mentioned. Only these two things are not available. And if there is any change company want to do, so that change also has to be made. So this is section 32 subsection 3. Now read subsection 4 also.
Ji, sir. Section Section 32, subsection 4. Upon the closing of the offer of securities under this section, the prospectus also stating therein the total capital raised, whether by way of debt or share capital, and the closing price of the securities and any other details as are not included in the red herring prospectus shall be filed with the registrar and the Securities and Exchange Board.
Yeah. So upon the closing of the offer, a date is mentioned that to which the person has to be make the offer for purchasing the securities, share or debenture. So the prospectus stating there in the total capital raise, whether it is through debentures, that is written there, or through the say by way of debt or share capital, and the closing price of the securities and any other details are not included in the red herring prospectus. So these details then would be filed before the registrar and even through the SEBI, because the registrar office, as I said, is the public office, and all the information can be gathered from by even under section 393 electronically also after giving the fee. So through the the registrar, the information can be sought. So how many total shares has been sold, and how much debt has been recovered or the share capital has been gained by the company, and what was the closing price, कहाँ तक वो बिके. So these information has to be provided to the registrar, and the registrar will include these information along with the red herring prospectus. Okay, so this thing. Now the next topic here is, after these different types of the prospectus, four types of prospectus: Abridged prospectus, what you have to read, section 2 1 and section 33. Then the Deemed Prospectus, what you have to read, section 25. Then the Self Prospectus, what you have to read, section 31. Then there is Red Herring Prospectus, and for that you have to read section 32. Now the next point or the next topic is, what are the matters that has to be written in the prospectus, and for that we have to read section 26. Yes, please read section 26.
Section 26. Matter to be stated in prospectus. Subsection 1. Every prospectus issued by or on behalf of a public company, either with reference to its formation or subsequently, or by or on behalf of any person who is or has been engaged or interested in the formation of a public company, shall be dated and signed and shall state
Yeah,
such information.
stop for a while. So here section 26 subsection 1 is saying that every prospectus issued by or on behalf of the public company, either with reference to the form with reference to its formation, or by or on behalf of any person who has been engaged or interested in the formation of the company, shall be dated and signed. So first thing here we have to observe that it's saying that every prospectus issued by or on behalf of a public company. That means this public offer, the public offer that require the prospectus is only in case of the public company. Then the next is that it may be at the formation, or it with reference to the formation or subsequently. So ये जो prospectus है वो हो सकता है formation के time पे भी हो, और हो सकता है बाद में भी कभी company को ज़रूरत पड़े, तो accordingly it can be done. Now read this later on. A.
Okay, so sir, actually the text in this slide and in the Bear Act is very much different, which I have.
Okay, okay. No, no, don't worry. You read it. Let me check that to. Yes, it's in my Bear Act also. It's actually changed one. Because I think it is the old one that we have before us, that we have downloaded. In the new, as it was amended in 2018. Now these clauses are not there. Clause A and then 1, 2, 3, 4, 5, etc. These 11 clauses, etc. These are not there. Clauses A, B, etc. are not there. Now, as I said, that the power is given that SEBI will through regulation वो सेट आउट करेगी कि कौन से मैटर करने हैं. So earlier when act was enacted in 2013, this was the old you can say before amendment 2018. The particulars were given here in the section 26. Accordingly we have to draft. Now these has been removed because maybe it is needed that sometime that a new particular has to be given, and whatever is in the statute is very fixed. Making a law is a very complex process and it takes time. So many times the government take the route of the delegated legislation. So here the power is it's saying like the SEBI, and SEBI through its regulation as in delegated legislation makes the rule. Changing the rules through the delegated legislation is much easy, and that's why it has been amended and it was added that state such information and set out such report or the financial information as may be specified by the Securities and Exchange Board in consultation with the central government. So from here all these requirement has been removed. Power is given to the SEBI, that SEBI through the regulation, and that very easy that may be changed even within 2 months, 3 months also, whatever the requirement. Because making the law static here is sometimes is adversarial to the shareholders. I think in the administrative law you have read Delhi laws case. There it was held that the delegated legislation is perfectly valid, but a guideline or the framework has to be formed. Okay, and in that the delegated legislation will work. Essential power cannot be delegated. So the this framework has been created. If you see Essential Commodities Act, there are 8 sections there in the Essential Commodities Act. And the government through its order make the changes that what is the essential commodity, what is not the essential commodity with the time. So it's the easy way to make it changes, and so it was there. Yes, read Abhishek now.
Sir, should I read the proviso?
Proviso also.
Okay, sir. Sir, I have to read from where I left.
Yes.
Okay, okay, sir. Shall be dated and signed, and shall state such information and set out such reports on financial information as may be prescribed by the Securities and Exchange Board in consultation with the central government, provided that until the Securities and Exchange Board specifies the information and report on financial formation under this subsection, the regulations made by the Securities and Exchange Board under the Securities and Exchange Board of India Act 1992, Act 15 of 1992, in respect of such financial information or reports on financial information shall apply.
So proviso is making that in the case the SEBI has not made the guideline, in that case what will happen. Now quickly come to the subsection 4, because subsection 4 is very important. Subsection 4.
No prospectus shall be issued by or on behalf of a company or in relation to an intended company unless on or before the date of its publication there has been delivered to the registrar for filing, a copy thereof signed by every person who is named therein as a director or proposed director of the company or by his duly authorized attorney.
Yeah. So here basically these are the preventive measure, that whether section 26 subsection 1 has been complied or not, whether the prospectus has having the all the information or the statement that the SEBI through the regulation from the time to time has prescribed. Who will check it? Company will say हमने तो किया. So they will register this document before the registrar, and the registrar will see it. This is the preventive measure, that is there any misstatement or not, because registrar is in the much better position. Registrar has the company's whole record, जो भी उसका पूरा लेखा जोखा है, when the company was formed, who was the director, everything. So the registrar has all these information, and that's why section 26 subsection 4 is saying that without delivering it to the registrar, it cannot be issued, it would not be valid. So that is the purpose of the section 26 subsection 4. Now you read section 26 subsection 8 also.
No prospectus shall be valid if it is issued more than 90 days after the date on which a copy thereof is delivered to the registrar under subsection 4.
Yeah. So when the this copy has to be delivered the prospectus, it has to be delivered within the 19 days. If valid issued more than 19 days, that means within the 19 days the prospectus, copy of the prospectus, or the date at which the prospectus is given to the registrar, within 90 days that you have to issue the prospectus for the public, because otherwise there may be the changes within the 19 days. So this is with respect to the further you can say the direction. Section 26 subsection 9 also you can read, but I'm not going to read now. And here it's about the penalty, or the punishment is there if the compliance is not there. So I will cover this portion when I will discuss the consequences or of misstatement and misleading statement, that we will discuss in the next class. So with this today I stop here. I just exceeded 4 5 minutes. If you have any question, quickly you can ask the question.